All rise. The Honorable Court of Appeals for the 7th District of Texas is now in session. Be seated. Good morning and welcome to the February 4th, 2026 setting of the 7th Court of Appeals. The case scheduled for argument is 07-25-00019-CR, Robert Stephen Jamerson versus the State of Texas. What says appellant?
All is ready, Your Honor.
Thank you. And what says the state?
State's ready, Your Honor.
Thank you. As we've indicated by letter, each side will have 20 minutes for argument, and then the appellant will have an additional 5-minute rebuttal. Any questions before we get started?
None from the state, Your Honor.
Thank you. Counsel? You may approach.
Good morning.
Good morning.
May it please the Honorable Court of Appeals. My name is Ross Lavin, and I am an attorney in Marble Falls, Texas. Just by real brief introduction, I know we have limited time. My first 20 years of law practice has been in Texas. Last 17 years, I practiced my other office in West Palm Beach, Florida. And I recently took my old job back after 30 years working for my first boss. So I'm back in Texas, and the boots still fit, and welcome back. Glad to be back. I actually tried a case in Potter County, an 8-liner case, I don't know, 25 years ago, but it's good to be back. Okay, I represent Robert Jamerson, and this is a very serious matter. And I'm glad to be here, and I'm glad to take the responsibility of representing Mr. Jamerson. He got life in prison and without the possibility of parole. And we're going to be discussing some very sensitive issues. Issues really aren't that complicated. I wish it was an aggravated assault and not a serious sex offense involving little kids. So I'm very sensitive to that. And I'm going to try my best to, when I address the issues, to be respectful to that side of the discussion. There's 6 points of error that are raised in appellant's brief: the denial of the motion for continuance, the admission. I'm going to kind of not attack them in order. There is a point of issue 2 and 4 where the admission over the objection of defense counsel of 2 extraneous witnesses. I'm going to call them extraneous witness 1 and 2. The little girl, we'll call her the victim. And then there was a denial of a motion for mistrial. That was after the overruling of an objection as to extraneous witness number 2. For reasons I'm not exactly sure why I arranged the brief in that order, but that's the way that they're arranged. And then there is an argument of ineffective assistance of counsel, and then there's an argument for insufficient evidence to support the conviction. I'm going to address the motion for continuance very quickly. It's an unusual. The point of error has some problems. I mean, it candidly, the motion for continuance was an oral motion for continuance. It was not a written motion. It was not sworn to. But the exigency of the circumstances may or may not satisfy what the Court of Criminal Appeals has told us, what you got to have on a motion for continuance, and that's got to be sworn. But the exigency explanation is that the trial set on December the 2nd, 2024, and on the 20th of November, the day before the pretrial, there's an amendment to the indictment.
Actually, sorry, it was on the 19th, November 19th.
The 19th. Then my brief is wrong. Because I think I quoted it being the 20th. Anyway, there was a pretrial on the 21st, and it was at the pretrial that trial counsel made his oral motion for continuance, saying, look, we got Thanksgiving coming up. I got to review the children's advocacy video. I've got to subpoena these additional witnesses.
Can I stop you for just a minute on that? With regard to review of the video, had the state already produced or had made the video available for review up until that point?
My understanding, since I was not the trial counsel, but my investigation is that they did make it available. However, it was not reviewed in the context of this new element of the amended indictment. They wanted to look at it again. And it was solely in the possession of the state, and they don't give out copies of that stuff. And with the Thanksgiving holiday coming up, it was difficult to arrange to see it. They finally did see it. But that was after the pretrial and after the motion for continuance.
Is there anything in the record that indicates counsel's explanation as to why they needed to review it again? Here's why I'm asking. There seems to be a lot of speculation about, look, I only had, short fuse on getting access to the video, but that's going to force us to speculate about why they needed to watch the video again if counsel already had access to it before. I was just curious if the record elucidates anything on that.
I don't think that the record is going to mention anything about that. Had there been something like that in one of the statements that were made to the judge the second time that the request for continuance was urged, I would have put that in the brief. But that said, that was one of the few arguments that were made for the request for a continuance. The other one is that they had subpoenas that they were trying to get issued, and they did get them issued, but they were never served. And they showed up on the day of trial, and they hadn't gotten them served. They're like, please, judge, we needed some additional time, and that was overruled. And based on, I'm going to leave it to y'all's, better judgment. I'm not sure if there's an exception that can be made based on what appears to be a hard and fast rule about the motion being requirement for that it be sworn to. But the exigency in this situation, especially when we're dealing with first-degree felony, where my client did get, life in prison without parole, perhaps some exception can be made, but I'm going to leave that to your judgment.
But you don't cite to any authority from the Court of Criminal Appeals, which allows appellate review of an unsworn oral motion for continuance.
I do not.
Perhaps that's something you can raise in a habeas motion later on if the judgment's affirmed, and counsel could explain then why.
That discussion has already been had, but my memory of the appeal process is that you've got to exhaust your appellate remedies first before you can seek habeas relief, but that has been discussed. But thank you for pointing that out, Justice. I'm going to address the fundamental why I'm here, why I think this case needs another look-see, a strong examination by this court and the granting of a new trial. And that is the overruling of the objection to the testimony of the extraneous offense witnesses. Now, EW2 is, I'm going to take them out of order, but I'm going to take them in the order that they were presented at trial. But numerically, I'm going to call her number 2 first. She was the sister of the appellant. And the record's not clear about what kind of relationship they had, but her testimony was fascinating I mean, I wasn't there to see it in person, but reading of the record, it was fascinating. She testified that when she was 3 years old, and she's in her 60s now, so more than 50 years prior, the appellant, Mr. Jamerson, had done this thing to her that is similar to the offense charged. And over the objection of trial counsel and the rule that is applicable is, of course, Code of Criminal Procedure 38.37, which allows for this type of analysis to be made by a judge to determine if that type of child victim evidence is admissible. And the test is there enough testimony, is there enough evidence to support a finding of guilt beyond a reasonable doubt? And I don't recall the case law discussing it the way that the state's brief discusses it, but the way the state's brief discusses it is that the analysis that the trial court has to make is to make a determination of the credibility of the witness. And I think that may be 6 of one, half a dozen of the others. But if she finds, in this case, it was Judge, it was a lady judge. If she were to find that there was enough evidence to support a finding, I suppose that is reasonable to say that she was making a judgment of the witness's credibility. But after she makes that finding, that doesn't mean it's automatically admitted, because the next step is the 403 analysis, where the trial court has to make have a hearing outside the presence of the jury to determine if the probative weight is possibly greatly outweighed by the prejudicial impact of this testimony. And therein is the crux of the state's best argument on why the case should not be overturned. And I anticipate that when Mr. Getz gets up here and is arguing to you, he's going to make an argument about, and it's in his brief, about the conflation of the two issues. One being the initial analysis under 3837, and then the second analysis under 403. And he calls it a multifarious issue, and I think that's what the case law calls it. And he's saying that's because it's a multifarious issue that it necessitates, maybe he doesn't really come out and say this, but it needs 2 different points of error, or perhaps 2 different objections, and having those objections be overruled. But I don't see it that way. And I don't think that the law in Texas should be that.
Well, can you explain then the different standards
I can.
that apply to each test for admissibility?
Well, the standards are set out in the language of the rules themselves. And under 3827, that allows for the introduction of evidence of extraneous sexual offenses committed by the defendant against others, provided the trial court, after a hearing outside the jury's presence, finds the evidence adequate to support a jury finding beyond reasonable doubt. So that's test number 1. And of course, everybody's familiar with test number 2, and that's the balancing test, the probative value versus the prejudicial impact.
At which point is the credibility of the witness evaluated?
The credibility of the witness for the purposes of 3837 is made prior to the jury hearing the evidence, in a hearing outside the presence of the jury, made by the judge in an inquiry where the witness is sworn to testify. And so the defense and the state both get to hear this testimony twice. The first time outside the presence of the jury, and if the judge finds that there is sufficient credibility or adequacy of the testimony to support a finding of guilt beyond a reasonable doubt, then and only then does the jury get brought in. And then there's another, exercise of the witness testifying and saying the same thing over again, this time in front of the jury.
So are you challenging the trial court's assessment of the credibility of the witness?
The objection was to both. There was not an objection made at the time. My reading of the record is that there was not an objection made at the time outside the presence of the jury as to the judge making a credibility finding. I think that the objection came later when there was the 403 analysis. But in my view, they're so intertwined that when you make that objection, that the weight of the testimony is far inferior to the, excuse me, it's far in excess of any probative value, especially when you're dealing with a 50-year-old claim, that single objection should suffice for both of those. And therefore, it's not a multifarious issue that embraces more than one specific ground.
So you're saying without regard to, and correct me if I'm wrong, but my understanding of what you're saying is without regard to the judge's finding of credibility, if there's any probative value from this witness, it's substantially outweighed by the risk of unfair prejudice or confusion.
Yes, sir. Based on many factors, not just the remoteness factor. And I'm going to get into remoteness in just a second, but I'm trying to make sure I answer your questions. So Mr. Getz, I think, is going to argue to you, I'm sure he's going to argue to, because it's in his brief, that because it's a multifarious situation, that therefore it's not possible for you to review it. That can't be the law in Texas. It can't be. You make a 403 objection, the prejudice outweighs any probative value, especially when you're talking about such a remote 1960s era allegation. When you're 3 years old, and then the record, which I'm going to talk about in a second, is replete with her testifying, not only do I not remember the details, I've blocked it out. That's got to go to there being so much unfairness that it outweighs the probative value.
Well, actually, this particular extraneous witness, her testimony was the abuse started when she was 9 or 10. It's the other extraneous witness, his daughter, that was 3. If I've read the record correctly.
I'm going to allow that possibility that I read the record wrong, but the number 50 doesn't change. It's still 50 years.
Right.
So if I made a mistake, it certainly was not intentional.
Once the judge makes the determination that the extraneous offense is going to come in front of the jury, are you aware of any mechanism other than just cross-examination if the judge maybe changes his mind about whether, so let's just say, hey, EW2, he finds credible, right? Then in front of the jury, she changes her testimony and he doesn't find her testimony credible anymore, just hypothetically. Is there a mechanism other than just cross-examining and impeaching her that you are aware of to change the 38.37 analysis or prohibit or strike the testimony? Or
the quick answer to that is there's really no way to get a judge to change her mind once she's made the decision except to make your objection and make a record. I wish that there was such a mechanism. And I want you to know I've got several other things to cover, and I'm watching that clock because I don't want that red light to go on, and I have to go over. Please forgive me, Justice. Did you have another question,
No.
sir? You good? So there is the case, and I'm going to share this case with you because it is not a case that's cited in the brief, and it's the case of Perez versus State, and it's a Fort Worth Court of Appeals case, and it's dated September 27, 2018, and it absolutely, did I give a site? I did not. 02-17-00236 CR. Oh, it's 562 Southwest 3rd, 676.
562 Southwest 3rd.
676, ma'am.
Thank you.
And in this case, it is a very similar factual case. And in this case, there was an analysis of this court, the Fort Worth court, had a case back several years previous where they said, 10 years, that's not remote enough. And then there was another case where it was like, oh, There was another case where it was like 25 years, and we thought, man, that's really gotten our attention. And then the Perez case is a 50-year case, and they're like, we agree with the appellant. It was too remote. So again, I'm watching the clock, and I'm going to ask you to please take note of this case. If I had more time, I would elaborate a little more carefully about my thoughts about Perez and its application to the case bar. So the bottom line is the trial court abused its discretion, and the extraneous offense evidence under 3837 does not insulate against a 403 analysis. 3837 does not eliminate the trial court's obligation to perform the 403 balancing test when a timely objection is made. The court must weigh the probative value against the potential for unfair prejudice, confusion, or distraction. Now, I'm not even going to get a chance to talk about the daughter of my client. She's testified. I'm jumping to extraneous witness number one. Her situation is that she was 3 years old when she says that she was assaulted similarly to what happened with the victim in this case, allegedly. And the testimony was that the victim was aware that extraneous witness number one had made somewhat of a celebrity of herself, writing poems and doing videos, talking about being a sex abuse victim, so that she's the one that after she had voluntarily moved back into this guy's house, and then she ended up moving out of this guy's house, my client's house, she called this lady directly. She was the outcry witness. And the testimony from that extraneous witness was that she was 36 years old and she was assaulted when she was 3, but she didn't. And this is set out in appellant's brief, the quotations from the record that demonstrate that this lady's memory about what happened is like almost non-existent, with the exception of, I know that these allegations happened. She's rather specific about that, but she can't say where she lived or the other specific matters set forth in the brief that talk about how unreliable her testimony is. I'm running out of time. I've got 15 seconds. I know I get another 5 minutes.
In both instances,
Yes, sir.
EW2, EW1, it sounds like you're making an argument that their testimony is so fanciful that no reasonable person would believe what they're saying, or at least that's what the argument you're making on why we should exercise our appellate authority to disregard that evidence. But the jury in both cases, or at least I guess there's an inference that the jury in those cases found that evidence was credible.
Well, it's not so much that they felt that it was credible, because they could have, as the court knows, found that my client was guilty beyond a reasonable doubt solely on the testimony of the victim. However, we don't have that situation. In this situation, we have the testimony of the victim, which is sketchy at best. And the record is replete with, in the appellant's brief, shows how the victim's testimony alone should not be enough to even, survive a motion for directed verdict. But because of the introduction of the extraneous offenses, that should not have, we wanted to overturn, not because the jury shouldn't have believed it. We wanted to overturn because the jury never should have been told about it, because the prejudice so far outweighed any probative value that the jury is not a sophisticated legal scholar to be able to separate what is could be fanciful, could be we really shouldn't look at that, because that's so remote, it's prejudicial. Their jury's not going to be able to do that. They're going to hear that they say that it happened, and they're going to add that on to what the victim said and find him guilty.
Let me ask the question a different way.
Yes, sir.
Hypothetically, suppose rather than your client was charged with this offense, your client was charged with ongoing sexual assault of the sister, for example. When we're talking about acts that occurred during the Nixon administration, let's just say it's just one, he said, she said.
Yes, sir.
Wouldn't you agree with me that if she took the stand and testified in that case that it happened, that at least under the state of the law we have in Texas, that would be enough to get to a jury?
Well, that would not be an extraneous offense. She would have been the victim.
Right, but my point was this, if it would be pertinent, it would be probative under those circumstances, why would it not be considered probative here, at least under the 3837 analysis?
Well, the 3837 analysis is the credibility question. So we're past that and we're into the 403 analysis. And I'm going to try and answer your question the best I can. I don't think that it would be any more appropriate for, notwithstanding any statute of limitations defense, for example. But if she was going to testify about what happened to her as the victim, that's really not a 403 examination at all, because we're not dealing with an extraneous offense, we're dealing with the victim.
You're saying when we look at 403, we don't consider 3837 at that point?
No, once we get past 3837, Mr. Getz is much more knowledgeable about this particular issue than I am, but I'm pretty sure the answer is once you get past the 3837, then you're into the 403 territory. And that's where we lodged our objection, but it inextricably had to do with both the credibility finding and the probative value versus the unfair prejudice test. So I hope I answered your question.
You did. Sorry, Chief. I'm sorry. I was over.
Oh, you're fine. Any further questions at this time? Okay, thank you
Thank
so
you.
much. Mr. Getz?
Thank you, Your Honor. Chase Getz, I'm an assistant district attorney in Williamson County, obviously. Thank you for taking the time to hear our argument today. I wanted to just jump into a few of the questions that y'all had asked over the course of appellant's oral argument. First is, Justice Yarborough, you asked if there's any other mechanism by which a party could ask the court to reconsider its prior rulings, and the one that the state is aware of is just a motion to reconsider. I'm just asking the court to just reconsider its prior ruling based on new evidence that's come out. At that point, the court would then do so, and if it agreed that basically on the change of circumstances, that it would then issue a instruction to the jury to disregard that testimony and presumably any other curative instruction that's required by nature of whatever said testimony was. Alternatively, the party could also move for a motion to strike. The end result is pretty much the same, but theoretically two different avenues by which that could happen. Justice Dawes, you had asked, let's go to your most recent question first, because since it's a little bit fresher in everyone's head. You had asked, ultimately, I think, whether or not the jury could have considered to have speculated on the evidence based on the remoteness of the allegations made by the extraneous witness number 2. So a jury is allowed to make reasonable inferences based on the evidence before it. They are allowed to make all credibility determinations. They are allowed to assign weight. And ultimately, that's what the state believes happened here. They heard the evidence. They determined whether or not, whatever way they should give it. To the extent that it's an extraneous offense, it's still required, the state is still required to prove it beyond a reasonable doubt. To your follow-up question for that, whether or not it would be enough here, the testimony of a single victim in what is effectively a he said, she said case, to prove if it was a case in chief beyond a reasonable doubt. The answer is yes, so long as the jury believed that witness, that her testimony beyond a reasonable doubt. As far as speculation goes, there's nothing in the record to suggest any sort of speculation. This victim, while her memory may not have been perfect, she testified very specifically to prior acts of sexual assault made against her when she was a child, again, 50 years earlier. But the state's recollection is she described, for example, one instance in which she was over at a person's house. She specifically described the person's house. She described the fact that she was 9 or 10 when it started. She described the fact that the appellant approached her while she was sleeping, and then proceeded to engage in various sexual acts against her.
Yeah, I was going to say, I don't know that I agree with the state's position that counsel's argument or the appellant's argument was multifarious, but obviously I wanted you to be able to respond to that. My concern was more a 403 objection necessarily tests the probative value, even in the prejudice portion, because we're weighing, or the trial court's weighing the prejudicial value against the probative effect. So to me, that's where 3837 can come in, though, is that 3837 is simply the funnel that allows us to look at evidence in a different way. It's just a bigger funnel than we ordinarily would have.
The state's understanding is that the reason it would be multifarious is to use a similar style of issue, is that while 3837 and 403 are linked, much in the same way, for example, the confrontation clause and hearsay are linked. They are themselves independent legal issues. 3837 concerns the credibility of a witness, in the sense that the court is determining whether or not sufficient evidence exists to submit the issue to the jury in the first place. The trial court, and this goes to one of your earlier questions, Justice Parker, for the standard is that the judge is, in that instance, the trier of fact for this preliminary hearing. They, much like any other sufficiency examination, they consider weight, credibility, they make determinations. It's near total deference. And ultimately here, the court determined that based on what she observed and what she heard, Judge King determined that the evidence was sufficient to submit it to the jury.
But doesn't questioning about whether certain evidence has probative value necessarily include an assessment of the witnesses or the evidence's credibility?
It does, Your Honor, as in the next step in the process. So now once credibility has been established, now we move into what would be effectively the concern about probative value versus the substantially outweighed by the various factors listed in Rule 403. So to your point directly, in 1990 in Montgomery v. State, which is the Court of Criminal Appeals case, they specifically said it is not proper to reconsider or reevaluate credibility determinations in the context of 3837 analysis, such that until that decision is changed, it seems to be a pretty hard divide. But to the extent that, to answer your question, having already made the credibility determinations, now the question is whether or not that relevant, credible evidence should be admitted at all. And 403 has presumptions that the relevant evidence ought to be admitted, and such that the question is whether or not it's substantially outweighed. Here, those factors that the court would consider are things like remoteness, which is what appellant touches on and the state touched on also. The Third Court of Appeals, in its opinions, has noted that remoteness alone is never grounds to sustain a 403 objection. There must be the presence of other factors that would lean against for example, like the state's need for the evidence, whether or not the jury was able to understand the evidence, whether or not it would mislead the jury, whether or not it was cumulative or would cause undue delay. It's the presence of those additional factors in addition to remoteness that could potentially warrant sustaining of a 403 objection. Here, the only complaint is on remoteness, that it was, in the case of witness 2, 50 years, in the case of witness 1, that she was 3, and now is some age older than that.
Just to clear it up then, because I think y'all are saying the same thing. The court should do the 38.37 analysis outside the presence of the jury. And then, assuming they say the extraneous offense evidence is going to come in, then if there's an objection to 403, do a 403 analysis?
Yes, Your Honor. Yes, that is how the procedure should work. But to the extent that there should be a reconsideration of previous credibility determinations. So, for example, to go back to witness 1, or extraneous witness 1, who said, I was 3 when this happened, and I remember it perfectly. That is a question of weight and credibility, and whether or not the prior effect should consider that evidence. remoteness touches on that, but that's not going to be the initial credibility determination.
Yeah, to me, saying it happened when I was 3 and it happened at a remote point in time, that seems to be the same conversation.
There is a distinction. I'm not sure that I'm able to articulate it well while in the hot seat. But if the court would like additional briefing on, I'm happy to try to make that distinction a little bit clearer.
Yeah, because I happen to agree with Justice Doss on if you're looking at the remoteness of that issue, I don't understand why it wouldn't be subsumed in the 38.37 part of the hearing.
Oh, sorry. In which case, just then maybe I do understand the question a little bit better now. To the extent, so it's again because they're necessarily linked. Because they're necessarily linked, the credibility determinations are always there. The question is whether or not you stop to say, "Do I find this witness credible now?" If you've gotten to the 403 objection, they are credible, and now the question is whether or not this credible witness who has said testimony that you presume to be true, for lack of a better term, whether or not that is outweighed by additional factors that suggest that it should not be admitted.
So what is the standard for this court in reviewing credibility determinations under 38.37?
So for 3837, because it is effectively a sufficiency review, this court would provide your total deference to the trial court determinations of credibility and weight.
If any reasonable juror, if any reasonable fact finder could find this testimony credible, then we find it credible, or we apply probative value, right? I mean, it's the same as we have under a Jackson legal sufficiency standard, right?
It would be the same under the sufficiency standard. To the extent the jury would find them credible isn't the concern, because this is a preliminary hearing and only the judge is the trier of fact. So it's the trial court's determination. And I hate to split hairs with you, Justice, but just
No. And I was trying to clarify the fact finder, meaning in this case, the trial court is the fact finder.
right. Yes, Your Honor.
And credibility is just one of the factors, right? I mean, that's not in the statute. Whenever I read the case law with 3837, we're looking, it's more of a legal sufficiency type standard where the evidence was adequate.
Mhm.
But credibility is just a part of that.
Yes, Your Honor. I mean, it's just a part of it, and it's one in which, again, the trial court afforded your total deference. And then we move into, again, the 403, which is a different set of standards and considerations for that.
But the normal rules of evidence apply in the 3837 hearing. I mean, if one of the extraneous offenses starts talking about hearsay, they can object to hearsay in that hearing.
I would think so, Your Honor. However, I did not specifically check that, and I would hate to make a misrepresentation. That being said, the court, of course, being experienced, would know what is and isn't permitted, such that even if that evidence were admitted, it's outside the presence of the jury. There's no real concern there, and the court would likely not consider evidence it shouldn't have considered. Now, to the extent that the other 403 factors are present, there are other considerations too, such as the remoteness, again, by itself not being sufficient. The other factors also weigh in favor of the admission of the evidence. So, for example, the state's need for the evidence, this is a he said, she said case. Case law is pretty well established that in he said, she said cases, proof of other offenses, sexual assault offenses against children are relevant. They support what is ultimately a attack on the victim's credibility, because the only real defense is I didn't do it and she's a liar. And so these serve to assist the trier of fact to determine that the case is that these prior acts did in fact occur, which is why 3837 again is once you get past that, you assume that the credibility determinations have been made as opposed to probative value, because the state says it's admissible for all purposes. Unlike Section 2, which is only for the nature of the relationship between the defendant and the victim, or that particular victim. In addition, although at trial, the appellant didn't address some of the particular factors in a 403, the state did at least point them out so the court can rest easy on that these all factors also were not, would also weigh in favor of the state. So for example, the evidence is not cumulative. These witnesses are the only ones who could testify to their own sexual assault. It would not mislead the jury because the jury is capable of hearing testimony regarding sexual assault and to know that it constitutes a extraneous offense. That's literally their purpose in this case and any other case in which sexual assault is alleged. To the extent that the jury might confuse the issues and rule and basically make their determination based on emotion. This case is itself a sexual assault case. The extraneous offenses are not any worse than the offense that is alleged. In fact, they demonstrate a similar set of circumstances in which case appellant appears to prefer to sexually assault children, generally around the age of 9 or 10, which is what extraneous witness 2 confirmed. The minor victim said that it started when she was 9, I think. And then of course, extraneous witness 1 stated that it occurred when she started at 3 or 4. Then basically continues until that person leaves the household and generally is characterized by him approaching them and sexually assaulting them while they sleep. And so it's the continuation of the same general fact pattern also weighs in favor of admission, or at least not sustaining a 403 objection. The defense did bring up, appellant did bring up Perez, which is a Fort Worth case, 2018. It is a published case. The state very, very quickly read through that. On one hand, obviously, the Fort Worth, even if published, would be persuasive authority on this court itself being a transferee court. But the state would note that to the extent that the claim is that there it found that the court sustained the 403 objection. The state would note that there were additional factors present. It wasn't just remoteness and is therefore in line with the Third Court of Appeals and its rulings that remoteness alone is not enough.
In your quick reading, the trial court sustained the objection or the appellate court reversed on it being too remote for the 50 years?
I would have to recheck, Your Honor.
Okay.
It was just that the balancing test, I'm sorry.
Assuming we find another factor and think EW2's testimony is too remote and was error to admit it, does it still go through a harm analysis for the rest of the case?
Yes, Your Honor. There would still be the harm analysis. And the state touched a little bit on harm analysis in the ineffective assistance portions of its brief. Here, the state believes that the harm analysis would again err on the side of affirmation of this conviction. Ultimately, regardless of the extraneous offenses, the victim herself did testify for the underlying case, testified in great detail as to the repeated acts of sexual assault committed against her over the course of 30 days. Exceeding the course of 30 days. That testimony itself is enough that if a jury believes her beyond a reasonable doubt, it could convict the appellant of the offense. And the jury did. They did in fact convicted. They found her credible. They believed her beyond a reasonable doubt. And if there are no further questions, I'll cede the rest of my time to appellant.
Just one quick question on the amended indictment.
Yes, sir.
I was trying to understand earlier about the video being available. Do you want to address that?
Yes, Your Honor, and thank you for bringing that up. I had it in my notes, but I did not circle it and missed it.
I do that all the time. It's okay.
So the record reflects that the video was made available to the appellant early on, as is required. Again, because it is a CAC video, he's not allowed to take it home, but he can view it at his when convenient for him. The record reflects that it was viewed to the extent that the claim is that he didn't review it for this specific offense. As noted in the state's brief, he still would have had to prepare for it. It was a extraneous offense. The proof is the same for the state, which is beyond a reasonable doubt. To the extent that it became subsumed into the underlying offense, all that does is just change it from a extraneous offense to basically an underlying predicate offense. Presumably, appellant would still address it, and here they did by pointing out the potential flaws in her memory and other types of things.
Does the timing of that matter? I may not need it during the guilt innocence phase, but I may need it during the sentencing phase, or
Well, it would still be part of guilt innocence because the extraneous offense is relevant for all purposes. As far as the fact that it's an extraneous offense versus a predicate offense, the state doesn't believe so. It's still relevant. It's still considered as part of guilt innocence. If there was a situation, for example, in which this was the second predicate offense, and the state had for some reason only alleged a single predicate offense in its continuous charge, which did not happen, then you might have an issue there because suddenly you've gone from a directed verdict because the state can't prove two events because it only alleged one. But that's not what happened here. And jury unanimity isn't required for continuous offenses, which is its entire purpose. Does that answer your question, Justice?
it does. Thank you.
Thank you.
Any other questions?
And the state would cede the rest of its time for what is left. Thank you.
Mr. Lavin, you'll have a 5-minute rebuttal.
Thank you very much. 5 minutes plus 40 seconds? No, sort of kidding.
Well, you did go over almost 3 minutes, which Dawson's questions, but we'll
It's fine.
be kind on the time.
No, that's perfectly fine. But as I said, yeah, please court. As I said in my opening remarks, this is a very serious case. And I'm going to be much more emphatic about that toward the end of this 5 minutes. To get to the nuts and bolts of this appeal, it has to do with the extraneous offenses and that they were admitted over objection, over timely objection. And the record is clear on that point. The fact is that the higher courts in the state of Texas, Court of Criminal Appeals, has given us the tools with which to work to make these determinations. And if you will look on page 13 of appellant's brief, it lays out the test. And I'm not gonna-
Assuming the state is right that you need something other than just remoteness under 403, what other factor is?
Great question. That's item 2 on my list, but I'll jump to it right now. And thank you, Justice Yarborough. The rule is remotelessness alone is not sufficient, but there is more. And if you will look at, I was previously just a few seconds ago directed you to the brief. On page 11 of the brief, it describes why EW2 should not be credible at all. She's the sister of Mr. Jamerson. She testified about his abuse during her childhood. She testified repeatedly under oath about her loss of memory, stating, "I don't remember a lot of my childhood." She testified she had another brother who also sexually assaulted her. She struggled with remembering the details of where she lived, where the alleged abuse occurred, and her testimony changed from the hearing outside the presence of the jury, which was just a few minutes earlier.
How did it change?
Well, she was, the details of how it changed, I'm almost certain from my memory of the record, is that it changed from, I don't have a solid memory of my childhood to I blocked out my childhood. I think that would be the
The only,
difference.
when I read the record, the only contradictory statement was that I could see was the town in which it happened. She mentioned Carthage versus Springfield, and then I think she corrected herself. I didn't find any other contradictory statements.
My understanding of the record, which is on volume 9, page 124, was that there was some discussion about her age when the abuse began, where her family was living, which is what you just said. And then when pressed on the changes, she said, "I don't have a memory problem. I have a memory blockage problem." I would say, in my humble opinion, that is more than just mere remoteness of 50 years.
Why are those factors that you just discussed, why are those not areas that are fertile for cross-examination
They are.
versus a threshold evidentiary admissibility question?
Well, great question. Number one, they are, but not yet. And what I mean by that is that if you take it as a threshold admission or non-admission, should it be admitted into evidence question, it absolutely is relevant under the how much weight you give it versus the probative value versus the unfair inferences that can be drawn. But however, if the judge determines that I'm going to let it in, well, then once it's in front of the jury, then it does become a cross-examination question. But it doesn't get to be the cross-examination question until the judge lets it in, which we don't think it should have been let in. Which is how come, and these things layer on top of each other, and I'm running out of time really quick. I'm going to direct you all to the Giglio-Bianca case on page 13. I'm going to direct you to page 16 of appellant's brief, which talks about extraneous witness number 1 and why she's not credible. I specifically in the brief point out that while she describes in detail the abuse, her memory is odd. That was a word that I struggled with. Rather than describing the incident, she describes it like a series of incidents. And I'm quoting her, or he would take me into the bathroom, he unzipped his pants, and she was very specific about it. But then throughout her testimony, she provided specifics as to the abuse, but she couldn't even say if she spoke with the police about it, or if she made a report, or if she ever spoke to anybody in the Children's Advocacy Center. And as Justice Parker, you pointed out, this started at age 10, not at age 3. So I'm not trying to beat up on extraneous witness number 1. That's not my purpose. My purpose is that this is more than just remoteness. This follows the language in Giglio-Bianca that requires certain things. Several of them don't apply in this case, like the lack of scientific evidence, for example. That's not an issue before the court today. But if you follow the law and the subsections of that test that are set out on page 13 of the brief, remotelessness enough is not enough. You gotta have more, and we gave more. There's more in the record, there's more in the brief. And look, the bottom line is that even if, well, let's put it this way, if you take out the extraneous offenses and you're left with just the testimony of the victim, in my view, that is insufficient evidence to support a conviction, which is point of error number 6. And it was inherently an unfair trial because of the introduction of these extraneous witnesses. And we're asking that the court reverse the case, order a new trial, and give this gentleman who got life in prison without parole a fair trial. Thank you.
Before you sit down,
Yes.
We haven't talked at all about the your ineffective assistance of counsel claim.
Yes, ma'am.
Did you develop a record on this particular issue?
Well, Your Honor, I'm glad that you asked that question. I didn't think I had time for it, so I'm very glad that you asked it. The situation is this. In the brief and in the record, it addresses a situation where on direct examination, the trial counsel for the appellant asked a question of a detective about abuse of extraneous witness number 1. And that just flew the doors wide open to letting him start talking about that when it otherwise perhaps could have been kept out.
And that was your allegation about ineffective assistance of counsel?
Yes, ma'am.
Okay. I did not see that in the motion for new trial.
Because the motion for new trial was written by me, and I had not had a chance to interview or read the record of the because the record hadn't been written yet. I didn't even get a chance to interview defense counsel. And we got hired like, you have 30 days to file a motion for a new trial, and we got hired like the guy was in jail and his family came and hired us like 3 weeks into that 30 days. There was really no opportunity to find that out, to put that in the motion for a new trial until we read the record. But I just want to point out one other thing since you brought it up. The state responded to, in their brief with regard to the ineffective assistance of counsel, with the following. They said, well, yeah, he opened the door and he let it in. Yeah, maybe that wasn't so great. Maybe he shouldn't have done that. But the testimony came in later anyway, and therefore there's no harm. Well, my answer to that is, well, maybe part of the reason the judge let it in later, in addition to, defeating the 403 analysis, was that it already got let in by defense counsel when they opened the door. So I don't want to speculate on that, but that could be the answer. The ineffective assistance of counsel is not just limited to opening the door like that. He shouldn't have done that, but he also didn't file a sworn motion for continuance. And that's not alleged in the brief, and that's something that perhaps should have been.
We don't have a copy of the hearing on the motion for new trial in the record.
I think it's not part of the record. I thought that it was. I asked for a copy of everything.
I don't believe it's a part of the record.
I think the findings of facts and conclusions of law are in the record, but not the transcript from the hearing.
I see. I regret that.
Thank
more
you very
questions?
much. Thank you.
I enjoyed visiting with y'all. Thank you.
The case is submitted. That concludes our arguments this morning. Safe travels to you, counsel,
Thank you, Justice.
and we're adjourned. All rise.